Good afternoon, everyone. So glad you are joining us today. Our topic is AI usage in the workplace and employment implications. And our law partner, Mark Davidson, is also going to do a review and issue spotting for the new Corporate Transparency Act. Next slide, Kemper. Yeah, so I want to introduce everyone. I am Beth Langley. I'm a labor and employment attorney with Brooks Pierce. My colleagues are Kemper, Patton. Kemper is in our Raleigh office and practices labor and employment. And my law partner, Mark Davidson, who practices commercial and business transactional legal work. It's kind of clunky, but Mark is with us today as well. So I wanted to do an overview of today's topics. So what we want to focus on, when we think about AI, we've been using AI for a really long time, but we've rapidly started experiencing a change in AI. It's become much, much more technologically advanced and more often used in the workplace. So we want to discuss issues about the use of AI in the workplace, the legal landscape that employers should really be focusing on in a proactive way. And as always, we're always looking at ways to avoid liability. And finally, because it's a very timely topic, Mark is going to give an overview of the Corporate Transparency Act. So before we jump in, please feel free to add any questions you may have to the chat box. Because of we've got a lot to cover today. We're going to address the questions at the end of the presentation, but do feel free to put your questions in as we go along if that's better for you. As always, we are just providing general information. This shouldn't be considered legal advice or substitute for consulting with your particular attorney regarding any legal matters that you may have about AI or the Corporate Transparency Act or other issues. So from there, let me turn it over to Kemper.
Thanks, Beth. So we want to kind of give an overview or have a brief discussion on artificial intelligence itself. As Beth said, given just kind of the use of AI has been increasing so much lately, we think it's just fair to kind of give a general overview before diving in. So the first most important question is obviously, what is artificial intelligence or AI? Well, according to AI, AI is a field of computer science that focuses on creating intelligent machines capable of performing tasks that typically require human intelligence. And of course, we thought it was only fitting that we cite ChatGPT for that. So applying that to our purposes, AI tools are made to, in some capacity, attempt to accomplish the day-to-day activities and tasks that would typically be reserved for certain employees. As Beth has hinted at already, we're not trying to, before we get into the weeds, we're not trying to really, convince you that AI is not meant to be used in the workplace. As you can see here, 99% of Fortune 500 companies are using AI in the workplace. So there's clearly many benefits to it. We simply want to inform you on the risks and the things to be aware of in using these useful tools. On that note, there are actually many AI tools that have been developed already specifically to be used by employers to handle various aspects of their business that are typically reserved for other employees. We have 3 examples here already: the Me bot, the humanly paradox. These are not, we're not sitting here outwardly endorsing these, but it's just to give you examples of how there are already different forms of AI that are out there specifically prepared for that relationship between an employer and employee, to run an employer's business, involving customers in that equation as well. And this also doesn't even include generative AI programs like ChatGPT, which might be used for various other matters by businesses and employers. So as we've gotten to, there's obviously benefits to having AI in the workplace. This is clear from ongoing trends that employers are seeking out employees that have experience with AI. And if simply put, if there weren't benefits, companies wouldn't be using them, and these AI softwares that I just mentioned wouldn't exist. So the question is, what are those benefits? As you can imagine, there are many, many benefits. It improves performance. It can remove risks that may be caused by human error, gathering and organizing data, sorting records, maintaining records. There's numerous benefits to them. To get specific on how employees and employers can benefit from those, there was actually a study done by the National Bureau of Economic Research that addressed these benefits, particularly in a customer service industry. And the results of that study indicated that having AI in the workplace can improve worker productivity and customer sentiment. It can also reduce employee turnover, as well as requests from customers for managerial intervention in the involvement with an employee and a customer. Specifically with regard to productivity, I believe in that case, employees were attempting to resolve various issues. And I believe the productivity increased by 14% when AI was introduced to that situation. On the customer end of things, I believe the study found also that customers were consistently reacting more positively when an AI tool was utilized during an interaction between an employee and a customer. And these improvements and these benefits were really magnified for employees that might have had less training, less skill, less time on the job, and things of that nature. So all in all, there's really no doubt that AI can play a very pivotal role in the workplace. So I'm going to turn it back over to Beth just for a brief discussion on what that role will look like and some of the ways that we've seen AI used in the workplace.
Thanks, Kemper. So particularly in the human resources realm, we're seeing definitely an increase in the use of AI in hiring decisions. Think about the software that's available that actually conducts virtual interviews, that takes someone's CV or resume, and from there suggests potential positions. In doing that, thinking about how that is screening applicants, but it's also steering applicants in particular ways. Kemper focused earlier on analyzing employee production. Data mining, data management has become increasingly more utilized. It's not just the really large companies who are outsourcing to a consulting company. Now with AI, you can do that in-house. We're seeing AI used in termination decisions, taking objective criteria and using that data to then generate which positions should be eliminated, which employees should be eliminating. And again, that's taking all objective factors. So it's taking subjectivity out of the equation. And also administrative functions. How long have we been hearing it's not particularly HR, but AI is replacing roles such as the AI receptionist, AI call centers. You're seeing chat bots, and we're seeing the same in HR functions. Some of those software applications that Kemper referenced earlier will even include chat bots for employees who have inquiries on HR issues. Automation, as we pointed out, of employee benefits enrollment in various programs. So it's a really broad application that we're seeing AI. And when we think about this, and we're going to talk much more in detail, all of these implicate confidential information, selection process to make sure that baked in biases are not in there. So with almost anything, the quality of your output is based on the quality of the input. One area where we're seeing a lot of use of AI is workplace surveillance. There so many employers now who have any employees on the road actually have cameras on those employees as they're driving, and is monitoring all of their driving activity and sending data back to the corporate office. You see as productivity, video monitoring, keystroke monitoring, even eye tracking software. So that in Zoom calls, we know whether someone's actually watching the screen or not. So these are all very sophisticated and now becoming pretty prevalent monitoring. Kemper is going to touch on when and how employee monitoring is appropriate, some privacy concerns, and also some concerns recently from the National Labor Relations Board. And another way we're seeing AI is actually where employee information is being retained. That is an area that we really want to talk about as far as liability risk, because is this an open AI where the information is being shared, or exactly how is employee information being utilized and who can access it? So when you think about that employee information, you're thinking about surveillance, you're thinking about information that's retained and gathered and retained during recruiting and the entire employment process. And then all of the administrative functions, payroll, transferring employees to new roles, those sorts of things, all those employee records that are now being, there's an AI component to how they're utilized and how that information is retained. So when we talk about data breaches, that is definitely an area where we have to be on high alert, because that's a potential risk to all employers. So Kemper, tell us about the legal landscape that we need to be thinking about with the use of AI in the workplace.
Thank you so much. So yeah, now we just want to discuss, now that we've kind of gone through the background of AI, how it's utilized in the workplace, benefits, it's really important that we consider the relevant law that may be implicated by AI in the workplace. The first sort of subset of law that I want to discuss is anti-discrimination law. The anti-discrimination laws are a huge consideration with AI tools. These can include Title VII, the Americans with Disabilities Act, the Age Discrimination Employment Act, the Genetic Information Non-Discrimination Act, and numerous others. Generally speaking, these laws are going to be enforced by the EEOC. And in fact, the EEOC has actually already published guidance on, informal guidance, you could say, on how employers need to be aware of the impacts that AI may have on their workplace, particularly with regard to the ADA and Title VII. So what do employers need to be concerned about when it comes to anti-discrimination laws and AI? How do those connect? Well, as Beth mentioned, a big way that AI tools may be used in the workplace is for these personnel decisions, hiring decisions, termination decisions. Of course, AI tools used in the workplace for these decisions likely do not just facially discriminate against an employee or a potential employee or an applicant on the basis of a class that is protected by discrimination laws, such as race, age, religion, and all the other ones that you can see here. And if they do facially discriminate, I would certainly hope that they're not in use. But with that said, most discrimination laws don't actually require what we call disparate treatment, which is the employee is treated differently because of the employee's or the applicant's alignment with one of these protected classes. Many anti-discrimination laws also allow for claims of disparate impact, which disparate impact claims differ in that under a disparate impact claim, you would see a situation where an employer might utilize a tool that, while not directly treating someone different because of their alignment with a protected class, it would nevertheless result in people of a protected class being disproportionately adversely affected. So an example of this, consider a test that an employer may use to determine which applicant to hire for a particular position. The test might be based on many innocuous things that seem fairly reasonable for a hiring decision, something intelligence, initiative, personality traits, things of that nature. But the question is, what happens if that test, while seemingly focusing on only very innocuous things, actually results in people of a particular protected class not being treated equally compared to other employees? If that's the case, then these tools might be considered a tool for discrimination. So how does that apply with AI? We'll say an employer is using an AI tool to assist in a hiring decision. That tool might be conducting all sorts of tests, completing tasks. Does the employer know how that AI tool makes its decisions, conducts its tests, how this tool analyzes the people that it may be reviewing? These are things that employers need to be aware of, because AI vendors can make promises all they want that their tools comply with anti-discrimination laws, but that's not necessarily going to be a get out of jail free card for an employer if that tool ends up being something that is a discrimination tool under a disparate impact type of claim. I think in particular, to touch on the ADA, this is one area that's really concerning for us, because the ADA prohibits discrimination on the basis of a disability. So consider the situation where an employer has an AI tool that is searching for the most qualified applicant to hire for a particular position. And the employer receives numerous applications for that position. Some of these employees perhaps may have a disability, and that disability might manifest in an applicant through various tendencies, physical cues, all sorts of different ways that there are many different ways that disability might manifest itself. So the question becomes, is that AI tool going to be able to disregard the direct and indirect aspects of that disability? This is something that it's really something important to be aware of. And also, is the employer going to be aware of whether or not that AI tool disregards the direct and indirect aspects of a disability? So in short, we have to be very aware of how AI tools are used in making personnel decisions in the event that these tools are potentially discriminating against employees or applicants. So next, I want to focus on, I want to transition from anti-discrimination laws and focus on labor laws. Labor laws, generally speaking, involve the employee rights to bargain collectively with regard to the terms and conditions of employment. So you can think unions, you can think collective bargaining agreements for this. These laws are typically come from the National Labor Relations Act, the NLRA, which is largely regulated at the federal level by the NLRB, which is also sort of spearheaded by the NLRB General Counsel. To very briefly summarize the NLRA, the sections that are relevant here, Section 7 of the NLRA protects the rights of employees to self-organize and to bargain collectively. So think activities that involve an employee's ability to work amongst other employees to improve their terms and conditions of employment. Section 8 simply makes it unfair or an unfair labor practice for an employer to interfere with those rights. So the classic example of this would be a group of employees discussing their wages. That would be, wages are a significant term of employment. And so employees are guaranteed the right to have those discussions about their wages by Section 7, whereas an employer's attempt to prohibit those discussions could be a violation of Section 8. So how does this involve AI? Well, at the end of last year, the NLRB General Counsel, who, as I said, kind of guides the prevailing views from the NLRB on labor law. The NLRB General Counsel at the end of last year released a memo stating that electronic and algorithmic tools that are used to manage and monitor employees may have a tendency to interfere with those Section 7 rights. And because of that, that would effectively lead to liability under Section 8. So this memo explains how the use of AI technology in particular can make it possible for employers to analyze and act on a large amount of employee data that's gathered by that AI tool. And if the employer chooses to either to act on that data or perhaps punish employees for protesting against the AI tools, the employer could be committing an unfair labor practice in situations that the employer does not have a very legitimate reason for using those tools, a very specific reason for using those tools. So in conclusion, there are really some serious concerns right now that the use of AI tools to remotely manage workforces, to collect data on workforces and to surveil workforces may be unlawful in certain situations under the NLRA, specifically when employers do not have a very, very specific, legitimate business reason for doing it. Now, it needs to be said that this was just an informal memo. It was not something that was necessarily passed as a ruling law, but it does serve as an indicator of what issues the NLRB is looking at and how the NLRB might analyze those issues. So next, I'd like to transition over to data privacy. Data privacy laws are a significant growing area of awareness. Data privacy laws are, on a very general level, they regulate the process for obtaining, using, and storing information about someone. So how does that involve employers? Well, that's someone who is having their information be obtained, used, or stored could be an employee, whereas the one doing the obtaining and doing the using and doing the storing may be an employer. And many of these data privacy laws have very, very, very specific requirements for how certain information, particularly very sensitive information, is used and obtained and stored. For our purposes, I mean, that could be a webinar in and of itself, but for our purposes, it's just necessary to be aware that using AI tools to manage this process may or may not cut it for adequately storing sensitive information. And that's going to largely depend on how that information is stored, who has access to that information. Is that information found on an internet server? Is it found somewhere else? That's going to be a big question that employers have to be aware of, and they have to be very familiar with how their AI tools operate when it comes to storing really sensitive information if the employer is covered by a particular data privacy law. Now, on that note, as of today, North Carolina specifically does not have a data privacy law, but numerous states do, and there's a massive one in the European Union as well. And these laws can be very, very broad reaching. Even if most of the business you conduct is in North Carolina, if you conduct some business or have some operations in states that do have laws like this, it's something that could cover you. And on top of all of that, this is just a really fast growing area of law, and it's something that employers can expect to be part of the future of the law and the future of what they have to be aware of. So it's something that we think is worth considering with how sensitive information for employees is going to be stored if it's going to be used by AI tools. So next, I want to discuss briefly, as Beth kind of hinted at, the aspects of trade secrets, proprietary and confidential information. This is really significant because many employers will have confidential information, proprietary information, trade secret materials that could be exposed to unnecessary dangers if they're mixed too much with AI tools. The concern here is primarily when confidential information or trade secret information is shared or stored in some way with these tools. Kind of as I was referring to with the data privacy aspect of it, it's going to be a question of how the information is stored on those tools, who has access to them, and things of that nature. So take confidential information. Say an employer is a financial institution. Generally speaking, financial institutions will have a duty to protect the confidentiality of its clients' finances. What if an employee uses a generative chat box like ChatGPT to help write an email to one of those clients involving financial information for that client? Is the confidentiality then lost? That's largely going to depend on how that on how the AI tool in question stores its material. Take an AI tool that manages businesses' materials and information. What if some of that information is a vast client list that has taken significant time, significant resources preparing? That could be considered a trade secret in some circumstances, but how secure, if an AI storage system is used for that, how secure is that AI storage system? The reason that's a really big question is because for trade secrets in particular is because under North Carolina law, it is a trade secret must have extensive measures taken to guard the secrecy of that information, or else it's not going to be considered a trade secret. So if AI tools store information in an unsecure manner, think like an internet server, something like that, then the information could lose that trade secret designation. So in some, using AI tools to handle confidential information, trade secret information, things like that, could lead to concerns about whether or not the confidentiality of that information or the trade secret designation for that information could be lost. And this is not quite a legal aspect as much as just good business practice, but it's very important to keep in mind that AI, particularly generative AI systems, can be wrong, inaccurate, or just very vague and unclear. So it's something to just be aware of going forward. If you're interested in hearing more about that, then you can look up the story about the New York lawyer who wrote a court document on that, and that will tell you everything you need to know. So on that note, I'm going to switch it back over to Beth for a discussion about some useful tips for avoiding liability when it comes to using AI systems.
Thanks, Kemper. Your last word of warning kind of raised a very recent development where one of the open AI's ChatGPT has been sued by the FTC for unfair and deceptive trade practices for actually generating inaccurate and in some examples defamatory information about consumers. So it's just something. I have nothing against ChatGPT, but it's just very much important to be aware that everything, just like everything you just read on the internet, is not always true. Everything that gets generated by AI can be, some things can definitely be faulty. So it has its place, and keep that in mind. So tips for avoiding liability. Every business is going to be different. So what we're going to talk about are general tips. First of all, consider your organization's needs for AI. Based on the type of business, your needs will be different, and your liability risk will be different, frankly. So if Kemper touched on data privacy issues, we already have many at the federal level. When you think about HIPAA information. When you think about at the state level, as Kemper talked about, various states have requirements for employers to keep personal identifying information confidential. And then you have, your business very well may be, one of your greatest assets could be your trade secrets and intellectual property. So depending upon your business, then your approach to AI and the tools that AI tools that you use in the workplace really need to be tailored for your needs. There's not one particular, we're not going to have a cookie cutter approach. But also keep in mind that since AI is a really big topic right now, employees are really alert to some of these risks as well, especially the risk of disclosure of their information. As NLRB rulings, when the NLRB General Counsel, when she issued her guidance last year, some of the examples she was using is that if employees who are subject to keystroke monitoring or video surveillance may have a so-called chilling effect on these employees to engage in protected concerted activity. And that in itself, just because there's a potential to have a chilling effect, would be a violation of sections 7 and 8 of the National Labor Relations Act. So again, employees are very aware of these topics. So make sure that on the learning curve, you get ahead of where they may be. Also recommend that you prepare an AI policy. It could be in your employee handbook, it could be a separate operations policy, but it's really important that employees at all levels, management and non-management employees, know what AI, the proper use of AI in your organization. So for example, that they're not inadvertently disclosing trade secret information, so that they're not disclosing confidential customer information or employee information. And it really, you're going to have to, a bank is going to have certain, financial institutions, folks in the education realm, you've got to think about FERPA. Healthcare providers have HIPAA obligations and statutory and common law privacy and obligations. So really, you need to customize what your policy is based on your use. Also, if you are using certain types of software in the regular course of business, how is that being used? What screening method is being utilized? And inform those employees who will be utilizing those AI applications as to the proper use and also what the screening process is before bringing on a new AI tool. Also, take a look at your hiring, firing, and disciplinary action procedures if you are incorporating AI into those processes. So, Kemper was talking about the EEOC's guidance late last year on ADA, and then more recently this year on Title VII and the use of AI. One of the examples that the EEOC used, for example, just kind of bring it home. What if you have an AI tool that conducts virtual interviews, and then you have this is totally hypothetical, but an employee who has a disability that's related to speech? That tool very well may screen out that individual because they were not as conversive or did not hit the objective communication requirements that AI put into the screening process. So it could be screening people out who were, with disabilities who are qualified for various positions. At the same time, if the AI is using historical data, and there's a workplace that has historically not hired persons of color or women in certain roles, then there's a high probability that that AI is going to continue to do the same thing, because that is, again, garbage in, garbage out. And that's what we need to make sure that, you know, the criteria and the objective data being used by these vendors is actually accurate and not discriminatory. When you talk about discharge procedures, when I mentioned this earlier, how this is how a way the AI is being used, we have to make sure that just by pulling certain objective factors, that we're not having an adverse impact on, for instance, persons over 40, or particular women, or folks of a particular race or gender orientation. So there are a lot of factors to take a look at that are still going to require a human overlay to make sure that, you know, you're not having a significant adverse impact. What we have found in the EEOC guidance is that traditional validation of tests that the EEOC has sort of approved of for the last decades is not going to be applied with regard to AI. AI is going to be scrutinized much more closely. So it's very important that you're selecting the right vendors and really having a human touch on these decisions that are getting made, and using AI as a tool, but not the end all be all. This is a nice segue into talking about understanding the tools that are actually being used. Again, making sure that employee information is being protected, that it's being utilized in the right way, and that the right security levels are put into place with regard to who has access to that data. If it's information that should only be retained in the company, then you really should not be using a generative AI that pulls in sources outside, or that shares in some sort of cloud environment. You really are going to have to keep an eye on the technicalities of this AI. And training is really important. Being very clear to train your managers and supervisors about the appropriate use of AI, and checks and balances, how information is to be stored, and also your staff in general. This is really important when it comes to particularly remote employees, and where maybe you're not having as much day-to-day dialogue with these folks, but they may very well be working in one of those states that has some extensive data privacy laws. So it's very important to keep that in mind as well. And at this point, what we're going to do is transition over to Mark Davidson and let Mark provide us a summary about the Corporate Transparency Act. And then we're going to reserve some time for questions.
Thanks, Beth and Kemper. Kemper, thank you. All right, well, so we're going to talk about the Corporate Transparency Act, as Beth said. It is a new law that was enacted. When I say new, was enacted actually in 2021. It's taken some time for the Treasury Department to implement and adopt regulations that will actually put implementation of the law into effect January 1 of 2024. As Beth mentioned, we were reserving time for questions. If there's something that I don't get to in this presentation, there's an article Melissa Bailey of our firm and I did that is available via email or via our website. So that will have more information. So everything I'm covering in this presentation is also in that article. So don't worry about taking notes. Of course, you have access to our slides here. But as an overview, this law is going to impose new information filing requirements beginning January 1, 2024. And in general, those new filing requirements are going to apply to an entity that has either $5 million or less in U.S. annual revenues or 20 or fewer U.S. full-time employees. Or put another way, if an entity has both more than $5 million in U.S. annual revenues and more than 20 full-time U.S. employees, that entity is not going to have to make a filing. That can be, though, misleading for many businesses. Many businesses are part of a group of companies or group of business entities. And so the main entity, the one with the operating business, likely will meet that requirement to itself, not have to report. However, it may have a sister entity. For example, an entity that owns real estate that is leased to the operating business. And that entity is conversely may be very unlikely to meet that exemption requirement because it doesn't have the requisite number of employees. So this Corporate Transparency Act is going to be relevant for pretty much all types of business entities. I mentioned 2024. So an entity formed before 2024, in other words, one now in existence, will have until January 1, 2025, a full year and a day, to make its first report. But beginning January 1, 2024, if we create a new business entity, then that new entity will have to make its first report within 30 days of formation. So Kemper, if you go on to the next slide. Thank you. So what did the filings do? They report identifying information about the individuals who participate in the ownership or control or the formation of that entity. The persons or individuals covered will include most of the individuals who own interest in the entity, either directly or, as I'll describe, indirectly, or who serve as senior officers of the entity. And certain aspects of the test for who has to get reported are kind of open-ended and vague, and I believe on a deliberate basis, as I'll explain. So that's going to create some uncertainty as to whom we have to report about. Next slide, Kemper. A key aspect to remember about this new law, though, is that changes in the information that you have reported have to be themselves reported promptly. So any changes in the information, either about a change in the individuals that you are reporting, so there's a different individual you need to report about, or any change in the identifying information about that individual that you've reported, has to be reported within 30 days. And this is not some annual update requirement. This is continuously monitoring for updates, which, as I'll mention later, can get pretty burdensome. And I'll explain through an example or two. Kemper, if you go to the next slide, please. So some background, why are the reasons for this law? Well, it's very easy to form a business entity. Any adult or business entity itself can file a simple document with the Secretary of State to form a new business entity. And each year, about 2 million new business entities are created in the US. And once an entity is formed, it can live forever, obviously, unlike an individual. So literally, there are tens of millions of business entities in the US. Kemper, next slide, please. With very few exceptions, most states do not require any reporting about who owns a business entity. North Carolina, for example, requires some annual reports about who the principal officers are, but not about just who the owners are. Next slide, Kemper. So because business entities are easy to form and their ownership is not reported, they are subject to being used to conceal the activities of quote unquote bad actors. So, for example, drug traffickers can take their drug trafficking proceeds and invest in a business through a business entity instead of themselves owning the business, or in other words, money laundering. Or another example, foreign persons who are prohibited from investing in the US may be able to circumvent those restrictions by investing through a business entity and not personally investing in the US. Next slide, please. So having said all that, the CTA is going to be about as fun as going through airport security, but it may help to remember when you're dealing with the nuisance of it, that it is important for our collective security, or so the government has determined. It's also important to remember that this information we're talking about reporting, it's going to the federal government, but it's going to be kept confidential. It's only going to be used for national security, law enforcement purposes, and potentially by financial institutions for their know your customer compliance. But in general, business ownership information is still going to remain private in the US, unlike in some countries where it's actually public. Next slide, Kemper. The individual does not do the reporting. Instead, the business entity reports about the individual. Next slide, Kemper. So there are three categories of individuals about whom a business entity is required to report. First are individuals who own or control a 25% or greater ownership interest. Second are individuals who exercise substantial control over the entity. And third are individuals who were involved in forming the entity. Next slide, Kemper. So the 25% or greater ownership interest, that is an individual either owning or controlling that level of interest. And when you look at what an individual owns or controls, you aggregate how the different sources by which they might own or control an interest. For example, let's assume that Mr. Jones, he directly owns a 20% interest in entity X, but he's also the trustee of a trust that owns another 5%. So in aggregate, Mr. Jones owns or controls a 25% aggregate interest in the entity, and the entity has to report him. That ownership or control can be held either directly or indirectly through another entity. Next slide, Kemper, please. So here's a simple example. Assume individual A owns 100% of entity 1, and entity 1 in turn owns 100% of entity 2. Well, it's pretty obvious entity 1 is going to have to report individual A, because A owns 25% or more of entity 1, and he does so directly. But entity 2 is also going to have to report A, because A indirectly owns a 25% or greater interest in entity 2, indirectly through entity 1. Next slide, Kemper. The second category of individuals that have to be reported are individuals who have quote unquote substantial control over the entity. And here again, there are three categories that we have to be concerned with. Next slide, Kemper. Thank you. First is, and most relevant for employment context, is any individual who serves as a quote senior officer, end quote. That's the actual term used in the regulations. And senior officers defined as a CEO, a chief operating officer, a president, chief financial officer, general counsel, and any other officer who performs a similar function. Next slide. The second category of substantial control is any individual who has the ability to appoint or remove a senior officer or a majority of the board of directors. Next slide. The third category of substantial control is any individual who has substantial influence over important decisions. So the regulations contain an expansive but non-exhaustive list of items that are deemed important decisions. This is the one I was referring to earlier, alluding to, that is where the gray area really comes into play. And I think I suspect it was deliberate. These other groups that have to be reported, they basically are, an objective. But they have to remember that the law is intended to deal with bad actors. And so if you have a bunch of objective, precise rules, well, the bad actors are going to try to think of ways to circumvent them. So this is the anti-circumvention rule that's going to make it very difficult for somebody who has, in any manner, how he or she has control over an entity, regardless of how they have it, this rule says they have to be reported. Next slide, Kemper. But that anti-circumvention rule, the grayness of it, creates some uncertainty for even legitimate business entities about who to report. And the conservative inclination is going to be, well, when in doubt, why don't I just report? It's safer to report as opposed to leaving something off that I should have reported when I certify this report. Well, the thing to keep in mind when you do that, though, is that, as I mentioned earlier, once you report information about an individual, that is then going to trigger the obligation to report changes in information about that individual. Next slide, Kemper. In the case of an entity formed after 2023, an entity must also report the persons involved who formed the entity. And so, for example, our law firm, I don't know how many business entities we form a day. I wouldn't be surprised if some days it's 50 or more, but and I'm often involved in that. And so I will get reported by these new business entities as somebody who was involved in forming that business entity. Next slide, Kemper. But what is the information required to be reported? It's pretty straightforward. You've got your full legal name. You've got a street address, not a PO box, a street address, and it's for the residents. Date of birth, a number on a government issued form of identification, such as a driver's license or a passport. And also, though, a scanned copy of that government issued ID that shows both the number and a photo of the individual. Next slide, please. In lieu of reporting all that information, address, date of birth, et cetera, it's possible to report a number for the individual that the individual got from Treasury that he can use and provide to an entity in lieu of providing his date of birth and residence. And it's important to note that this is a new number. It's not your Social Security number. An individual is going to have to basically go to Treasury and say, okay, here's my date of birth, address, et cetera. The same information that the individual would have to provide the business entity, they will provide instead to the Treasury, and the Treasury can issue them a number. And again, that individual can then go and provide that number to the entity instead of having to provide date of birth, street address, et cetera. Next slide, please, Kemper. I don't know if this is intended or not, but the CTA does not itself impose an obligation on someone, an individual like me, for example, to actually provide an entity with the information that the entity is required to report about me. So an entity should consider imposing this obligation on the relevant individuals by agreement. Next slide, Kemper. The CTA imposes civil and criminal penalties for willful failure to provide the required information. So imposing an obligation, the entity imposing an obligation to provide that required information may help avoid a penalty. So with respect to the entity's owners, that obligation could be included in the organizational documents for the entity. With respect to the senior officers, it could be included in employment agreements or in the employee handbook. But what if, despite these obligations, an individual declines to provide some of the information? For example, a scanned photocopy of the driver's license. Next slide, Kemper. Fortunately, the Treasury's draft of the form of report that an entity will file suggests that Treasury is very aware that an entity may not be able to gather all the information required to be reported. So there are boxes that it can check that essentially say unknown or unavailable. Next slide. There are some important exemptions to the entities required to report. Public companies, entities for which there is already substantial regulatory reporting, such as banks and certain tax-exempt entities. Next slide, Kemper. I've already mentioned the most important one in terms of potential broadest application. That's called the large operating company exemption. That's where you have more than 20 full-time U.S. employees, with full-time generally meaning 30 hours or more per week, more than $5 million in U.S. annual gross receipts or sales reported on a federal tax return, and an office in the US at which the business is conducted. Next slide. So the requirement to file an update within 30 days of any change in the information, though, may be very burdensome. For example, the business hires a new CFO, and update is required. Well, what if the old CFO leaves on January 1 and the new CFO is hired March 1? Well, apparently 2 reports are required because there's been more than 30 days between the 2 incidents. Suppose the CEO or 25% owner moves into a new home. A report is required, an update is required. Next slide. 2 practice pointers real quickly, and then we'll end here. To reduce the entity's burden in having to report changes about an individual, such as a change in residence address, an entity might want to consider requiring that that individual do the alternative and get a number from Treasury. Because what that will do then is that will shift to the individual the obligation to report any changes, say in a residence address. Next slide. And finally, as I mentioned, entities in existence on December 31, 2023 have a year to make their first report. But once the first report is made in 2024, that's then going to trigger the obligation to file an update for any changes. There's no benefit to be had by filing that report early in 24. Might as well wait until later in 24 before filing your first report. So that concludes what I had to say about the CTA. Beth and Kemper and folks in the audience, are there any questions in the couple of minutes we have remaining? If we don't get to your questions or questions occur to you after for either Beth and Kemper's presentation or mine, you know where to contact us. We will promptly respond to them.
We'll also be posting, here's a question, will we be receiving a copy of the slide deck? And yes, we will email you a copy of the slide deck, and we'll also post this up to our website, both the video and a copy. Please give us a couple of days because it takes a little while for the video to upload, but we will get those copies posted and a slide deck sent out to all the participants.